If anyone wants or is even thinking about introducing an agrovoltaic project to their land, then you have to go through the RMA. At the moment, most people know all about the RMA, and it's both the planning framework, which regional, local councils have to make plans for and a lot of people's input into, but it's also the other side, the consenting framework. Under those plans, you're going to know what's a permitted activity and what you need to get a resource consent for. Farmers in particular are very well aware of that range of activities that need permits, what you can do with your water, what you can do with your land, what you can do with your trees, that kind of thing. Any agrovoltaic project at present is going to need a resource consent. There are no plans around the country that have already got them as permitted activities. For example, you're going to need some kind of resource consent, and there are going to be probably more than one type of consent to go through, both at the regional council level and at the local council level. So you know that you're going to need to put poles in the ground, you need to cover a large area, it's going to look very different with shiny big solar panels covering a large amount of ground that reflects the sun. You might have to have earthworks to build roads. You might be building shelter belts. There's a huge number of activities that might affect the soil, the water, and the view, and then maybe any indigenous plants and animals, flora and fauna. You're going to need resource consents from your regional council in relation to maybe the water runoff panels. Are you going to need to dig drains? Then the soil and the sediment control, that's a significant concern. The regional council want to make sure that's been thought about. But the poles for the earthworks is another one. Are you going to build roads? Your local council, you might need a consent for earthworks. All of those will be often bundled together for at least the local council and the regional, and sometimes you can bundle them all together in one application. And they can be treated sometimes together in one application, say one hearing, one set of decision makers for the whole lot. You can see from the scale of the developments that, and all those possible consents and the different types of effects that it might have. So in any consent, you have to provide the councils with all the information that they will need to assess those effects. They want to make sure that the benefits of your agrovoltaic project don't come at too many costs and that everything's been considered. All of those effects need to be studied and provided to the council in advance. So you're going to actually need to engage with someone who can assess those. Sometimes you might go to a one-stop resource consenting person. There could be a planning outfit that will have access to, for example, the planners who can tell you what the rules are in your local plan. Every council around the country has got different rules, right? That's the whole point of the RMA at the moment. It's designed to let communities set their own rules. Right, within an overarching national policy framework, but communities choose your rules, so it means they're different all around the country. That's one key point. You can't say just because, say, Selwyn District Council got one through, doesn't mean Waikato's going to. Right, so you've got to look at all the different rules. And then, of course, everyone, even within the same district, you've got different land, different effects. Some are on hills, some might be near Wahitapu, that's not going to be affected now with maybe sheep and normal farming, but would be affected with construction. So you still need to get all of those effects assessed. And so you get a planner, typically, to tell you what the rules in the plan are that you need. I mean, a lawyer will do the same thing. But then they're going to advise you on the people you'll need to assess those effects. You might need an ecologist to tell you, are there any endangered species in your area that your construction is going to affect? You might need a landscape visual artist, a landscape assessment, to say, what is that going to look like? Are you right next to, let's say you did it on the plains beneath Te Mata Peak. That's going to completely change the view from Te Mata Peak, right? Would that be a consideration that everyone would object to? You're saying you're ruining the aesthetics from somewhere else by having to look at your ugly agrovoltaic array, right? That is a concern. You might need a landscape assessment for that kind of thing. Yeah, there's a whole range of possible effects. You might need a cultural assessment report for any effects on, say, cultural heritage in the area. You'll need a geotechnical report to make sure the land is stable enough to have the poles, and there's one consent that was applied for where the site was over an old landfill, so they needed a soil contamination expert to make sure the poles weren't going to dig down too far, right, and get into the old landfill material and release contaminants from underneath. So what you need depends on your site, but you have to be able to assure a consenting decision maker that you've considered all of the possible effects, and that also includes the benefits, remember, not just the negative effects, but also the positive effects. You might have an economist or someone who can talk about the jobs. If you talk to your solar developer, they'll be able to provide the financial assessment and the energy inputs, what you can produce, what you can give to the grid, and then what benefit that would make to the community, as well as the individual. So there's individual benefits, but also community and maybe national benefits that can be assessed. All of that needs to be in an application. And of course, you can imagine on some of these big ones, some of those applications to run to hundreds of pages. You need a lot of different reports from experts to be able to persuade a decision maker that you've thought of everything and nothing's going to go wrong. Because of those considerations, every single project is completely site-specific. You can get some guidance. It really pays. So all of the planners and the lawyers will be looking at all of the other projects that have been either approved or denied. So all the planners and the lawyers who work in this area will be looking at all the previous decisions, the ones that were approved, the ones that were denied, and to look at exactly what it was. So to give you an example, just recently in the same month, the one project was approved down in the South Island and another one was denied. Completely different sites, right? Completely different consenting bodies as well, but one of them was on Crown pastoral land with a lot of threatened Indigenous biodiversity. But they hadn't given the information about what the effects would be on their biodiversity. They hadn't done the right assessments, and it was actually denied on lack of information and the risk of damaging that biodiversity. If they'd had the information and shown there wasn't the risk, they might have got through. But the one that was approved, even though it was over a possible contaminated site, they had all the information. Otherwise, it was a normal farm. Been used for agriculture, there wasn't a threat of biodiversity loss, and the benefits were clear. So every single one's got completely different circumstances, different rules they play by, and different assessments. So the pastoral lease one didn't need a geotechnical soil contamination assessment, whereas some of the same landscape considerations weren't needed on the other agricultural lease. If you've got a wetland, you're definitely going to need an ecologist assessing what you need to do for the wetland. You might need to be doing some fencing, that if you haven't already. Another aspect of the site specificity, right, is every community is different and how they get their energy. Right? We have a lot of communities with a lot of solar, or solar just starting, but the grid is also different. All right, what it can handle. And so that's an assessment that your solar developer will make. And this may be an unfortunate aspect of the grid as it is at present, but if you've already got a number of solar arrays, you might find it more difficult to add your one to the mix. And so in some respect, at the moment, because of the grid and the way it's set up, it's a little bit like first in, first served in your local community to connect to that grid. So another aspect you're going to have to consider, or maybe not you, but your solar developer, and we'll have to provide a report on this to the benefits, is your local grid. Every local grid has a different capacity. So you're going to have to get an assessment of what it can handle and how big your project can be. What is economic in your particular situation? So remember, what we're talking about here is the large solar arrays. Energy provision that goes back to the grid. We're not talking about not necessarily talking about the small ones that a farmer might use for their own purposes. Everything is going to depend on the plan. obviously, what's permitted and what needs a consent, but we're generally only needing a consent for the large ones. And remember, of course, because all the plans differ in different areas, every city, district and region might have different rules. So obviously you have to check on what you're allowed to do as of right, but generally then all the rest of the things that I'm talking about needing a consent, those are for the very large ones that we're talking about feeding energy into the grid. So it's an industrial type activity, or certainly a commercial one, but it's an industrial size of producing energy to feed back into the grid for other people. So one of the really important parts of the consenting process, and most people are concerned about, is when the public can get involved, or the notification of your consent, and what that means for the people around you. One of the first things you might want to do after you've got an initial description of the project and maybe some of the assessments, from your solar developer and perhaps some of the other experts that have been contracted to write about it, you have to have some kind of idea of the project, the scale, what it's going to look like, have some drawings, right? One of the early things you should do is consider talking to neighbours and other members of the community to get some feedback. One of the sticking points you'll often find in the process is what we call the notification process. Because any consent, the council has to decide whether a consent is going to be notified just to the neighbours or to the whole public. Right. And at the moment, because agrivoltaic arrays are quite new, communities aren't used to having them. Most people don't like new things. So one of the considerations for a council in deciding whether to make something, to notify it publicly, is the novelty and whether people will object or not. And in the Wairarapa, for example, that novelty and the visual effects being very different was the reason for notifying to the public. Public notification slows your process of consenting down and it makes it more expensive. So it's really good to early on once you've got an idea of your project, you might want to workshop it, around informally if you have a small community, just to see if you can maybe get some tweaks that people will like. Your experts will also be able to advise, for example, on what's the best landscaping so you don't ruin people's views. You might need an expert to consider the light reflection, right? Because these do bounce light off. If you're in an area with hills and roads, are you going to be ruining the vision of drivers with light reflecting and bouncing in their eyes as they're driving, especially on a major highway on a hill nearby? That can also be a matter for, say, reserves, significant natural areas, significant natural landscape areas. You might need to assess the light reflection. So that's why you need to get the assessment from the experts first, to be able to say, well, these things are things to think about and these are what might be the effects, and then ask them what are the ways to mitigate them. But your neighbours might also have suggestions for what will mitigate it for them. And if the neighbours are all happy with it, you can actually get their sign-off to say they're happy with the conditions, and that will make your consent sail through a lot more smoothly. So the time frame is going to vary completely as to what the council decides it needs. If you've got all of the information, which might include all the assessment of the effects, you might include permission from the neighbours, then that could go through really quickly if it gets decided in-house in council and doesn't go to an independent consenting panel, and if it doesn't require public notification. You can actually get them through quite quickly. But if it's going to go to notification, especially public notification, and if it goes to a panel, then that can take an extra few months. A panel might make a decision, have a hearing. Once it's had a hearing, it's got to make a decision really quickly. It's what you don't know in advance, and so that's where a consenting team can help you, tell you what you need to do to satisfy all the requirements in the RMA. And if you get those in and you try and do it properly, you can often get it through quite quickly. Where a lot of them have fallen down and been denied as well as been delayed is when you don't have enough information, especially about environmental effects. The Renewable Energy Generation National Policy Statement, that was introduced in 2011, and it didn't have agrivoltaic solar arrays. So we already currently have a national policy statement framework that tells councils they should be prioritising renewable energy development. But agrivoltaic arrays don't fit neatly into the requirements and the words, so there's a review underway at the moment for the whole national policy framework to make agrivoltaic arrays easier to approve. So there are lots of changes that happen in the RMA regularly, and especially in response to renewable energy development, because we know that for climate change purposes we need to be completely renewable as soon as possible. Net zero by 2050 is like the minimum. Okay, so, and in order to get net zero, we have to have our renewable energy component ramped up. Well, I think we've got a goal of 100% renewable electricity by 2030, and 50% renewable of all of our energy requirements in New Zealand, including, like, say, fuel for transport, things like that. So that's going to require a lot more shifting to the grid, and it's going to require more changes to the RMA to get these projects through more quickly. And more easily, I should say. It doesn't necessarily mean quickly, but it means to prioritise them over, say, objections on the view. One big issue is going to be is what other matters and effects would they be prioritised over? For example, what about those environmental effects, the endangered species in the Crown Pastoral Lease? Is renewable energy really important to put there as well, or should we be prioritising it elsewhere? So we don't know exactly what the framework will be for the new proposals and where it's going to go forward, but we are certainly going to see even more changes to the RMA to prioritise agrivoltaic arrays. The RMA, of course, has changed in relation to different political priorities and different factual situations, social priorities that we find ourselves in. One example that has actually enabled fast-tracking of large projects, which could include agrivoltaic arrays, is the COVID-19 fast-track process. That was one designed to facilitate energy and other infrastructure projects, and to make them to get through more easily. It was also a jobs and an economic benefit underlying that as a reason for doing it. This COVID-19 fast-track process enabled infrastructure and very large development projects to go through a little bit or a lot more quickly than if they'd gone through the RMA process. That had a completely separate set of rules and decision makers, had its own panel, retired Environment Court judge chairing it, but it had a panel of decision makers and a much faster process, fewer considerations, probably less paperwork overall. They still had a hearing, and you still had to have a lot of information about the effects, but they were able to get through projects more quickly. The new coalition government has proposed an even faster track, including renewable energy projects, and one that will replace even that COVID-19 process. So we may find that these renewable energy projects could get through even more quickly. So in one sense, it's bypassing the RMA. We've yet to see what information they're going to require. They're probably still going to require all of that information about effects and assessments. It's just a much fast-track decision-making process.